Congress may have taken its battle against the Election Commission to the streets, but now it has suffered a major setback in the court. The Supreme Court has dismissed Congress leader Meenakshi Natarajan's petition challenging the rejection of her Rajya Sabha nomination from Madhya Pradesh, and in doing so, the top court has effectively upheld the returning officer's decision and reinforced a long-standing principle of election law that courts cannot interfere once the electoral process is underway. And the controversy erupted after Meenakshi Natarajan's nomination papers were rejected over alleged deficiencies in her affidavit. The Congress accused the Election Commission of acting unfairly and alleged what Rahul Gandhi described as seat chori. The party then launched protests, held a satyagraha at Delhi's Jantar Mantar and sent a delegation to meet the Chief Election Commissioner. But on Friday, the Supreme Court declined to intervene. The court held that disclosure requirements under Form 26 are mandatory. Candidates are required to provide complete details through their election affidavits, including information relating to criminal cases on them. The court made it clear that disclosure obligations are not limited only to cases where cognizance has been taken or charges have been framed, but in the other cases too. The Supreme Court also referred to established legal precedents and observed that challenges to nomination rejections cannot be entertained through a writ petition once the election process has begun. The bench then relied on the well-established principle laid down in its election law that judicial intervention during an ongoing election process is extremely limited, and the court ruled that Meenakshi Natarajan's petition was not maintainable. However, it granted her liberty to pursue an election petition before the High Court after the electoral process concludes. In other words, the legal door is not completely shut for Meenakshi Natarajan, but the challenge will now have to follow the route prescribed under election law. The verdict comes as a significant setback for the Congress, which has been aggressively targeting both the Election Commission and the BJP over the issue. Rahul Gandhi had even alleged a BJP EC jugalbandi jibe at them and questioned why Meenakshi Natarajan's nomination was rejected, while other candidates were allegedly given opportunities to rectify errors. The Supreme Court, however, has chosen not to enter the political debate. Instead, it has focused on the legal framework governing the elections. In fact, viewers, we spoke to Meenakshi Natarajan. Here's that exclusive conversation.
कांग्रेस की राज्यसभा प्रत्याशी जिनका नामांकन रद्द हो गया वो सुप्रीम कोर्ट गई, वहां भी उनकी याचिका खारिज हो गई। मीनाक्षी नटराजन हमारे साथ है। मीनाक्षी जी, याचिका खारिज हुई है, क्या कहेंगी? क्योंकि राहुल गांधी भी जोर शोर से कहते आए थे कि वोट चोरी के बाद सीट चोरी हो रही है।
तो ये तो बहुत स्पष्ट है कि रिटर्निंग ऑफिसर्स कॉम्प्रोमाइज्ड थे, चुनाव आयोग कॉम्प्रोमाइज्ड है, और सीधी सी बात यह है कि ये हमारा जो मामला था वो तो चुनाव आयोग से जुड़ा था, लेकिन आज माननीय उच्चतम न्यायालय में स्टेट ऑफ मध्य प्रदेश भी रिप्रेजेंट हुआ, तो ये क्या गठबंधन चल रही है ये भी बहुत साफ तौर पर समझ में आता है, और इसके खिलाफ हम लोगों के बीच में जाएंगे और लड़ाई लड़ेंगे।
अगला कदम क्या होगा मैम?
हमारे पार्टी के सब वरिष्ठ जन मिलकर हम लोग सब साथ में मिलकर तय करेंगे।